Hello, good morning. Welcome to another edition of Coffee with CartLaw, Alabama. I'm Daryl Cartwright, and today I wanted to talk to you a little bit about estate planning, but specifically powers of attorney and how they can be used in your estate plan. So let me go ahead and share my screen with you and let's get started. You know, a lot of people will go in and talk to their attorney about their last will and testament and getting their will done, and that's great. But a power of attorney should never be overlooked because that can be very, very effective. Powers of attorney can be either general or limited. And a limited power of attorney, and sometimes you'll hear someone call it a special power of attorney, is really of limited benefit to you in your estate plan. Basically, they're done for other reasons, such as to allow someone else to sign your name for a real estate closing or to transfer a motor vehicle or something of that nature. Limited powers of attorney have a limited, specific kind of purpose, and they generally go away after that purpose has been accomplished. Not effective for estate planning. Estate planning powers of attorneys need to be a general power of attorney. That gives the agent, the person you are authorizing to act for you, the power to do basically anything that you could have done yourself. That's what you want in an estate plan. Power of attorney may be durable or non-durable. A non-durable power of attorney is one that becomes invalid when you, the principal, becomes incompetent. That's not what you want for estate planning. In fact, that's exactly when you need it the most. So you always want to look for a durable power of attorney because a durable power of attorney means that it remains valid when the principal becomes incapacitated. The next one is a little bit different to the state of Alabama and some other states, but not all states, and that is whether a power of attorney is a springing power of attorney or a sprung power of attorney. Now let's take these in reverse order. A sprung power of attorney means that it is sprung into effect immediately. When it is signed and notarized in front of a notary, then you, the principal, are giving an agent, the other person that you name, the power to act for you immediately. And that can be a dangerous kind of thing, or hopefully it won't be dangerous because you trust the agent, but it's effective immediately, which means that they can go out and do anything that you could have done with the power of attorney because it has sprung into effect. That's not when you need it the most. You need it when you become incapacitated, and that's where a springing power of attorney will come in handy. Springing means that it springs into effect when something else occurs, some triggering event. For example, you becoming incapacitated or incompetent, or say several years go by and you are still competent, but you're just tired of dealing with your own financial affairs and want to go ahead and give someone else the authority to act for you, then you can execute something like a certificate of authority, if your power of attorney allows for that, to trigger the agent and their authority to act for you immediately. One thing to keep in mind is a power of attorney is only valid during lifetime of the principal. I've had scenarios where I've had a client that came in and we were talking about probating a loved one's estate, and they said, well, I asked about a bank account, and they said, well, I used my mama's power of attorney and I went ahead and transferred all the money out after she died. You can't do that. If the bank had known, they would have pitched a fit. Well, they wouldn't have pitched a fit, they just would not have allowed it. Power of attorney expires at the death of the principal. So what's the summary? For estate planning purposes, you need to have a general power of attorney. A limited is going to be of limited or no benefit to you. Power of attorney also needs to be a durable power of attorney so that it endures the incapacity of the principal. That's when it's needed the most. And then the third and the final is whether it's a springing power of attorney or a sprung power of attorney will depend upon the facts and the circumstances surrounding your individual situation. You need to talk with your attorney about the scenario, your age, the reliability of the agent, and a lot of other factors possibly coming into play on that. Talk to your attorney about all that. If I can ever help you with any of this or anything else, feel free to give me a call. You guys have a great day, and I'll see you next time.